Thanks a lot, Khaled. And thank you again, Kathleen, to join this webinar. As you may know, we have been doing some of these webinars for past more than 3 months now, or almost that time since March 23rd when the lockdown started. And while this topic was under contemplation as to how do we, discuss this topic, we thought it may be best suited if you join us, particularly with your past experience and our current interaction with you as the co-chair of the ICA-IBA Joint Task Force on Data Protection in International Arbitration. So idea about this webinar was to bring about some guidance to understand the international perspective on data protection, which in India is at a very, very nascent stage. Uh, while we do have our proposed law being discussed for a few years now, but the current law as it stands is just a very basic rules under our Information Technology Act. And therefore, most of the advice on data protection, dealing with personal data, privacy issues are, based on, general advisory rather than any, major statutory interpretation. So while we are waiting for our full blown law, we thought it may be a good idea to get this perspective. And therefore, since there is still a chance to, contribute to that law being developed, this can be, one medium to, suggest few things which may be taken into consideration. So that was the background under which we thought we will have this webinar. And we would also talk a little bit about the joint task force. But before that, let me, bring you right away and get your, basic sense on the data itself, right? In an international arbitration scenario, there are several stakeholders, there are several parties, individuals, corporates involved, and there is a huge amount of data which gets uh, processed, which gets transferred. So what's the basic role of data, and why are we talking about data protection so far as international arbitration is concerned? If you can bring in a little context and background to it.
Great, thank you. I'm not sure if I need to push something so you see my video, because I'm on video, but I don't see myself. I only see you.
We can see you very well, and you are
Okay,
perfectly
fine.
visible on the main screen. So
Great.
I guess the participants are able to see. Yeah.
Great. I love not to look at myself, so that's great. So to your question, so
You,
the core
yeah,
of international arbitration is the use of a private mechanism to decide disputes. Today, and this is a change over my 30 years of practice, today, arbitration is almost invariably the mechanism of choice in transactions between international players. Not uniformly, but increasingly. And that is a change. Even between European players, where they have an easy ability to enforce a court judgment, arbitration has become the mechanism of choice. So what is the basis for international arbitration is the exchange of information, the exchange of data in order to allow the parties to prove their case or defend their case. Over the years, arbitration has come to an agreed paradigm which is somewhere in between the common law system of very large amounts of discovery, which, as you can tell from my accent, although I've been based in Europe for most of my career, my heritage is American. I went to law school in the United States. In the United States, although it's changing some, we've always done very wide scale disclosure, discovery, very wide exchanges of data. European practice is to exchange nothing. Almost no witnesses, you exchange briefs and the judge decides, right? And arbitration is somewhere in between. It's really closest in terms of disclosure to the English model, where you have to have a basis for disclosure, but if you prove that so each side presents their case, which is already a huge amount of personal data, and then you can ask for more from the other side. So inherent in the process is a huge amount of exchange of personal data, because under the data protection laws, personal data includes everything that will allow an individual to be identified. So in an arbitration, every witness, every person who's indicated in the evidence, every arbitrator, every lawyer, every ICC official or Indian arbitration official, they all have rights. It is there. And that's one thing I would just say at the outset. It is very important to keep in mind that under the modern data protection laws, the rights and obligations apply to individuals. So if I'm sitting as an arbitrator, which is typically my role these days, I have my own obligations. If you are counsel, you have your own obligations. The party own obligations. So all of these different obligations, which are often governed by different laws, have to be complied with in the context of this arbitration, because everything we do in an arbitration is the processing of this personal data. So that means in practice that the data protection laws provide an overlay to whatever rules you're applying, to whatever, let's say you're looking at the IBA rules of evidence in that case. The GDPR, whatever relevant data protection law applies, provides an overlay. So yes, I comply with the ICC rules, but I also have to comply with the data protection rules. So that's sort of a background to
Sure.
how
No,
I see the two.
sure. So that's very, very helpful, and that gives a context and the extent of importance of this topic, because the amount of, as you rightly said, the amount of data which gets exchanged and the overlap of so many different jurisdictions where you might have obligations to compliance. It's important that the arbitration professionals understand their obligations whenever they are conducting such a proceeding. So going little more uh, before going into more generic on that, but more specifically to GDPR, considering your understanding of the European regime uh, and how GDPR works in this context, right? Does GDPR becomes the sole and the most important regulation here, uh, particularly when we are talking about dealing with the European Union privacy and data protection law, and how would that apply in the context of arbitrations?
So the GDPR is applicable to one of these individuals. Again, it's not applicable to the case as such, but it's applicable to one of these people involved in the case, the party, the arbitrator, whatever, if they either are established in the European Union or if they have reached out and tried to attract the case or the matter such that the processing of personal data occurs. So if your firm is going along nicely in India, doesn't spend a lot of time trying to attract business from the European Union, you're probably not covered by the GDPR. But if you're involved in an international case, that may not matter much, because if you pick me as an arbitrator and I'm governed by the GDPR, or if your opposing counsel or party is governed by the GDPR, or if a witness is governed by the GDPR, it comes into play. So, and what the GDPR does is it applies. So one thing I think, to just take a little step back for those who may not be as au fait with data protection history, the 1995 Data Protection Directive does virtually everything the GDPR does, virtually, except it didn't have teeth. So what the GDPR did was, among other things, but primarily it said, by the way, it's going to be a very large fine if you violate this law, 4% of worldwide turnover or a minimum level of fine. So that made everybody take notice. And now, so the rules that are applying in arbitration have applied since 1995, but everybody ignored them. And now they're paying attention. So it's not new news, but it is new news in terms of compliance.
Sure.
So the GDPR has a very broad application, but if you have no connection to Europe and you don't reach out and try and attract business from Europe, you're probably not covered. But that may have no relevance for your arbitration if somebody else is.
Sure. So therefore, it's, while one would generally understand that, look, why should I worry about the general data protection regulation? As you rightly said, I have no connection with Europe, but you never know when that would start applying in the context of your case or an arbitration, which we are talking about. And maybe there may be some consequent obligations which can fall as part of that process. So that obviously is important for one to understand. So all of this is what possibly led to the joint task force by ICA and IBA, particularly to help the arbitration professionals to get through and understand the data protection and the obligations thereto in relation to any arbitration, or at least international arbitration proceedings. Maybe you can give us a little background to how the whole task force came about, and where are we in the process, and what ultimately that task force would produce as part of this group, which will help the arbitration professionals in the conduct of their proceedings.
Yeah. So one thing I would like to just say briefly, well, no, I can say it in the context of this question. So in March, let's say March of last year, the English bar, so the barristers folks, went around to the various chambers in London and said, you know, guys and gals, the GDPR is coming into play May 25th, and it applies to all of you whenever you do an arbitration, heads up. And until that moment, everyone was merrily ignoring the GDPR in the same way they had ignored the Data Protection Directive. I had given a talk in Fordham and written an article November before, and, they all thought that I was, I don't know, because how could this possibly be? There must be some confusion. We just have to explain to the European Union what we do in international arbitration, and they'll clearly give us an exemption, no problem. So there was this, educational process up until that date. But after the English, bar got wind of this, there was a little bit of a, lots of hand wringing, and everyone knew from the last 15 years that I've been saying, someday we're going to have to start worrying about data protection in arbitration. That I was probably the one in the international arbitration community that knew something about this. So, and I had already worked with ICA on their cybersecurity document. So And given the very broad international scope of this problem, ICA and the IBA decided to join forces and to come up with a document and very practical materials that would help the international arbitration community grapple with this in short order. So that is what we have done. We think we have done. So last February, about the day that lockdown occurred in some countries, so our timing was not terrific, we issued a draft of our roadmap together with the annexes. And we will now do a revised draft, taking into account what we've learned from the pandemic and also what we've learned from the excellent comments we've received. Your firm was very helpful in preparing that document. We're very grateful to that, for that. So that's where we are. Now, one thing I'd like to just use this as a moment to say, which is we originally wrote the roadmap primarily around the GDPR. We said, you know, the GDPR is the gold standard. So we essentially wrote a GDPR-based compliance document. We got a lot of pushback on that because 75 countries of the world, not including the countries of the European Union, also have data protection laws, which are based upon the old Data Protection Directive. So what we did for the draft that was published is we created a more neutral version that doesn't go into the details about any specific law, including the GDPR, but talks about general compliance. Because our view is that eventually, when people really accept that this is the law, we'll come up with a set of compliance mechanisms that become standard practice in international arbitration, no matter whether you can do the detailed analysis and decide you're covered or not. So that's what the roadmap tries to start us on.
Excellent. So thanks a lot for that understanding, and I'm sure this roadmap, once finalized, would be very, very helpful in grappling with this very, very complicated issues about the compliance under the data protection regime across the world. So with that, let me bring a little bit more context to this topic and where India stands today, because large part of our participants are obviously first dealing with the Indian situations. And while we don't have a full-blown law already applicable, there are obviously suggestions to that. Some of the guidance is already issued, it is under public consultation, and then we already have the rules under the Information and Technology Act. So let me bring in Aaron, my colleague at NDA, to give a little bit of context to privacy and data protection as applicable in India, and why that would also apply in the context of arbitration, considering the kind of control, processing, and transfer of data which would happen in any arbitration proceedings, even if it is purely in an Indian context. So, Erin, can you give your perspective on this?
Sure, Vyapak, thanks. I'll start by saying, there are 3 or 4 broad points to be kept in mind on the privacy and data protection front when dealing in arbitrations, in international arbitrations. Before I get to some of this, let's take a step back and look at the entire arbitration ecosystem. Who are the major stakeholders? Who are the major parties in an arbitration ecosystem, right? So you start with the tribunal, you have an arbitration institution, you have the counsel and the lawyers, you have arbitrators, you have the parties. Obviously, the parties may consist of individuals, the parties may consist of entities, legal entities, who in turn may have shareholders. The clients and company may have shareholders, employees, ex-employees, directors. Moving away from the client side, you also have stakeholders on the support side in terms of court members, tribunal members, You also have external service providers. You have everybody from security providers to storage platform providers, translators, consultants, forensics, um, investigators, as well as other providers who are with the arbitration institution, right? So there are many parties involved in an entire um, arbitral proceedings that take place. So it's important to understand at first what role each party is playing in the arbitral proceedings. Under data protection laws, and I can speak for the GDPR to some extent and to a larger extent in terms of the Indian data privacy laws, we do have a concept of data controllers and data processors. Now, data controllers are those parties that primarily collect the data, but more importantly, determine what is to be used or how the data is to be used and what happens to that data. You have the data processors, which are more of third party entities in the nature of service providers who act on behalf of data controllers, who act under specific instructions from the data controllers. They may or may not have a relationship with the person to whom the data belongs, right? So these are the two broad categories. Primarily, it's your data collectors or data controllers that are liable to comply with the data protection laws, and the data processors who need to contractually fulfill their obligations to a data controller. Now let's move on to see what are the objective of these legislations, and I think that's where it'll help apply the principles to the arbitration process. Firstly, these, whether it's the GDPR or the current or proposed framework in India, these legislations propose to protect personal data of individuals. So the moment you're dealing with data of a company, it is not protected under Indian law. Personal data is that data which can identify individuals. Some of the data protection laws go a step further and categorize certain sensitive kinds of data which are subject to higher thresholds of protection, right? So not only at the first instance will each party or each stakeholder in the arbitration ecosystem need to determine what kind of role they are playing, they will also need to see what kind of data they are handling and whether such data is sought to be protected, sought to be regulated by applicable data protection regulation, right? In most cases, what happens in arbitral proceedings is likely to fall within the gamut of the regulation, as data protection regulations are very wide to overall cover processing activities. Now, processing activities can range from anything from collection to use, processing, analysis, even sharing or disclosures, pretty much anything related to use directly or indirectly of the data. So it's most likely that such activities would constitute processing, but it's important to understand the exact role played by the parties. What is the data that is in question and being handled, right? The third is the actual application of the law, and this can probably be done at an initial stage as well. All these things should ideally be done in parallel. Whether, because when I say application of the law, I'm not only talking about application of the law of the land, I'm talking about application of data protection regulation. So as Kathleen initially said that when she introduced the GDPR, so the GDPR has extraterritorial application. Our current information technology laws have very limited extraterritorial application, but our new proposed framework in the country, our revamped law, has similar provisions on extraterritorial application as the GDPR. So it essentially, you could be anybody in the arbitration ecosystem. For instance, a third-party service provider, say providing data storage services or analytics, or even legal advisors of financial providers. But if you are meeting the nexus test, the law will be applicable to you. And the result of that is that compliances would kick in, right? For instance, if you are conducting business or systematically providing goods or services, then the law of that particular jurisdiction of whom such individual belongs to, that law will apply to you and you will need to comply with that law as well. So we're looking at, in certain cases, and I know Vyapak will get into such practical cases later on, Vyapak and Payel as well. But in such cases where in international commercial proceedings you have multiple parties, but you have application of multiple laws as well. And in such cases, what needs to be done is that data flows have to be very aptly set out in privacy documents, notices, disclosures. It has to be very clear what each party is playing, what the role of each party, what are the data flows, where data is being processed, where it's being stored or retained, and where it's being erased from. And essentially, in terms of transparency and disclosure, this needs to be done in essence to comply with various laws, right? For instance, the notice requirements under Indian law may differ from other laws, right? But if such other laws apply as well, then in essence, all the different disclosures would need to be made. So, these are some of the things that need to be kept in mind when going about arbitral proceedings. So I'll leave it at that. Yeah.
Sure, sure. One follow-up question. While you touched on that aspect a little bit, but maybe we can discuss a little bit more before we bring in Payal, is in reference to the different applicable laws, because it is in the context of the individual involved, and there is bound to be a conflict of some positions, or at least the interplay or the overlap in those laws, because as you rightly said, everything will be applicable based on the individual involved and the jurisdiction from which that individual comes from. And you'll have to look at the data flow from that aspect. So, is there a guidance on how to reconcile some of these positions? Uh, is there a thumb rule that you use based on who is the controller, who is the processor, who has the first obligation to deal with or comply with the obligations? How do we, have some kind of a basic rule or some kind of do's and don'ts so that people don't trip on any of those compliances?
Sure. So some of the points you said, Vyapak, are very good, but unfortunately, a lot of them lack in terms of the reading of the law. And there is ambiguity in a lot of these aspects, especially in cases where multiple laws may apply, right? In certain international arbitrations, you may have an arbitrator sitting outside India, an arbitration taking place in another country, individuals or clients in a third country, and service providers in a fourth and a fifth country. And hence, you may have a gamut of data protection regulations from each of the countries applying, right? In such cases, what each stakeholder, each party in the arbitration proceedings, what they will need to do is to sit down, assess what are the applicable laws. Are they meeting the the nexus test so that the law applies to them? Set out in their documentation, for instance, if it's say a financial advisor, if it's a legal advisor with a client, have the contract in place with the client, take the necessary consents to not only comply with one law but to comply with other laws as well. In fact, we often talk about application of multiple laws, but sometimes the beauty of it is that by taking care of compliance under one law, you are also doing it under another law, right? So in terms of your disclosure documents, in terms of your consents that you take, and in terms of your agreements that you have in place with the data subject, as well as third-party service providers, take care of all the compliances that need to be adhered to under the different applicable regulations.
Sure. Thanks a lot, Aaron, and I'll come back to you depending upon how time goes on this webinar. But coming to little bit more on Indian context, but bringing in arbitration in the forefront. So, Payal, what's the practicalities involved, right? In terms of what Aaron said, in terms of the basic applicable laws for data protection, but from the context of arbitration proceedings. At what junctures and stages that one needs to be careful of any compliances, and what kind of practical experience you have seen so far in in an Indian context particularly when it's an international commercial arbitration involving parties from several jurisdictions, including where some of these laws are pretty much there for a long time now.
Thank you, Vyapak. I think the way that we started off the webinar, Kathleen summarized it very beautifully in a very simplistic language, the application of data protection laws when it comes to international arbitration. But unlike Aaron and Kathleen, I think my job is slightly difficult because I will deal with the section which shows the ambiguity, the vagueness, and no amount of clarity which is there when you're trying to interplay these laws in the Indian context, especially when it comes to Indian arbitration law and the proposed framework of data protection laws in India. So to begin, the first statement I would say is, if as an arbitration lawyer, the question which is posed to me is, how do you see the proposed framework applying? There is no clear answer. There is clarity how I'm going to actually apply it. But how do we try and come out of it? The first aspect which I would deal with is there is a provision which is provided under the proposed framework, where it talks about legal proceedings being exempted. But before that, what is the current law today? The current law says you are required to make a disclosure pursuant to a court order to comply with your legal obligation pursuant to a request. Now, that is something very different from what we see in an arbitration proceeding. Now, the question that arises from the proposed framework perspective is arbitration even covered under the concept of legal proceedings? Now, in all likelihood, it will be. We have Supreme Court rulings in our country which says arbitration is included in the ambit of legal proceedings, because legal proceedings is actually a broader term. It includes judicial and non-judicial proceedings. By virtue of it, it's not just restricted to court proceedings. So we can also apply it to arbitration proceedings as well in India. But once we apply the what it says is there are certain exemptions which have been drawn out in the proposed framework, where arbitration proceeding has, if going by the concept that it will be included under legal proceeding, gets exempted. By that virtue, we can conclude that the data proposed framework is not going to be applicable when it comes to arbitration. Now, where do we actually see this interplay? We have parties who are disclosing information, which could, let's start at the beginning. When you're approaching an institution, you're starting with the request of arbitration itself. It includes your name, your addresses, your email addresses, and you're sharing it with the institution. If it's an ad hoc, obviously you're directly sharing it. If it's an institution, you're sharing it with the institution. Then comes the arbitrator and the other side. There are multiple parties which are involved in this case. If we have a pure play domestic arbitration, I mean, Vyapak can correct me over here because he has sat in several arbitrations as an arbitrator in the Indian context when it comes to ad hoc as well as international arbitrations. I don't think this is the thought which easily crosses the mind of the arbitrator, because arbitration is something, as we understand today, is a process where it's with mutual consent of the parties. The parties voluntarily are sharing the information with each other and disclosing the details. So the question of actually applying whether the disclosure has been done, the manner in which it has been done, how it is going to be utilized, and the interplay has never really come across in the strictest sense in Indian context, I would say. So, I mean, in my limited experience as an arbitration counsel, I have not seen in the Indian context, especially with just a proposed law now coming into place, the arbitrator actually dwelling on the issue of data protection laws. The maximum they have gone into the extent is, how do you ensure and maintain confidentiality of the documentation at basically at the stage of production of documents and your evidence, how you're sharing information and what information is being shared, and whether you're maintaining confidentiality towards it. The second aspect toward the other angle, I would say, is the international arbitration. If it's an ICA, which is seated in India, it's the Indian law which is governing the arbitration proceedings. The second angle is where it's an ICA with an Indian party, but seated in Singapore. Then it's a foreign jurisdiction arbitration. You have an Indian and a Singapore party. Singapore has a developed data protection law. So does that automatically mean that in Singapore law, if the party seeks protection of those disclosures, it's the Singapore data protection framework which will be applicable? And by virtue of India not really having a framework, there's nothing to abide by or any groundwork laid down for that purpose. I think interestingly, this question would come up even more right now, considering we are in the new normal where we are facing virtual hearings. We are having video recordings. We are having a lot of document sharing through various servers. We are having a lot of sharing of evidence as well as witness hearings also happening virtually. How do these laws actually apply? Where is the server actually situated? How is the data being processed? I don't think we really have any clear answers when it comes to the Indian context because there's a lot of vagueness and ambiguity. It is one thing to say that we might be exempted by virtue of the proposed framework, but the question is how does it address the question of transparency, or how does it address the question of even the data protection laws, the very purpose of trying to come up with a framework to ensure that privacy is maintained, disclosures are done in a proper manner? How do I ensure it even if I don't know the interplay between the two laws? And I think most importantly, we believe, we want, and to some extent have come to a stage where India has developed as an arbitration hub. It becomes all the more important to understand the interplay of the two laws because you might just be faced in a situation where it's an international arbitration where you're seated in India but with such foreign parties who have their own developed mechanisms and guidelines in place. How are you going to apply them when it comes to India? So I think for me, my end, one short point is we need a lot of answers. We need the government to look at it as Justice Krishna in the report had clearly said, Arbitration Act is going to be affected by this proposed framework. So the question is, how are we addressing that issue in the Indian context?
So, since there are too many questions, let me go back to Kathleen because it seems we are getting a lot of answers from her, at least, to some of the problems that we are facing. So, Kathleen, coming straight to you, uh, there is a provision in our proposed law which talks about exceptions, or to that extent saying that some of the important provisions of the law would not apply in the context of uh, disclosure of personal data for enforcing any legal right, or for legal advice from an advocate in any impending legal proceedings. Do you think such exceptions uh, do exist in other jurisdictions as well? And does that insulate arbitration in some sense? Or the general understanding would be that arbitration still would get covered so long as the data you know is concerned. So you have to just see where and how the data is getting transferred and processed.
In the European Union, there are similar exceptions. However, those exceptions are worded differently, and the wording is tailored towards member state court proceedings.
Okay.
And if you then look at the remainder of the text around it, it's pretty clear that they did not intend this to apply to broader to legal proceedings. There are other provisions of the GDPR that allow for data transfers, et cetera, where the term legal proceeding is used. And there, the view taken in the roadmap and by the arbitration community is that those provisions do encompass arbitration. So, and there are laws like the Swiss law that very specifically exclude arbitration from the gamut. So in California, not because it's so specific, but for a variety of other reasons, essentially the data protection law won't apply as such to international arbitration in most cases. So hearing the language for the first time, I'd have to take a closer look, but my own view is it sounds like that would be an exemption, so that the Indian Act would not apply to arbitration in India as such. But I can tell you what the Swiss experience has been. Now, Switzerland is a much smaller, place than India, obviously, but it is an arbitration hub. And they have found that arbitration exemption has gotten them about that much, because it only helps them in cases where there is no party and no counsel and nobody that's governed by the GDPR. So
Sure.
although they can say the tribunal isn't covered by the Swiss Arbitration Act, somebody else is covered by another arbitration act. But as much as one can give legal advice based upon a webinar and without looking at the law, it sounds to me that analogizing to the similar provisions of the GDPR, you probably have an exemption for purposes of Indian Act.
Only that may be the way to interpret, but as Payel was saying, the main drafter of the data protection law is one of the most prominent arbitrators and ex Supreme Court judge from India, and the draft report do mention that it will have an effect on arbitration law. So we do not know what was going in the mind, because it's not that the drafter of the report is not concerned or is not aware of how arbitration would work, particularly when the language used is any legal proceeding. So anyway, we'll see how that develops over a period of time. But coming to some of the points that we discussed earlier, but taking it a little more specifically, and the issues related to who stores the data, who transfers the data, who processes them, how that affects the applicability of the data protection law in terms of arbitration. Is there again some guidance? Is there a general understanding as to how those situations would be handled in an arbitration scenario?
So what the roadmap says is that, going back to the points that Aaron made, is that for purposes of categorizing the different actors in an arbitration, that virtually everybody's a controller of data, which means that the more stringent rules apply to them. The only people who can justify their activities as being data processors, at least within the European Union, are translators, people who look at documents where they have very strict instructions from counsel what to look at. But the lawyers, the institution, the arbitrators, the lawyer, they're data controllers, which means that the broader laws apply to them, and there's precedent for that. That says that a lawyer is a data controller, and analogizing that language to what others do in an arbitration is pretty clear. But then there's the interesting issue of who might be a joint controller, because joint controllers have joint and several liability. And so there's a lot of debate amongst the arbitration community. My personal view is that that's hard to say. And it may be a case-by-case analysis. I believe the tribunal, it's pretty hard to say we're not a joint controller. The rest of the parties, I'm more open to thinking about how that might be in a particular case. But because there's a risk of being considered a joint controller, that's why the roadmap quite strongly suggests that everybody adopt a data protection protocol early in the process, because then it defines who does what, and that's required if you are a joint controller.
Sure.
So then the question becomes, what's the lawful basis for processing? And now I'm referring to countries that have either laws based upon the Data Protection Directive or the GDPR. And there, I think this is a place where Indian data protection law and other laws, I think, are really diametrically opposed. So my advice to everyone, if you listen to one thing that I say, is stay away from consent. Consent is a really bad idea. The lawful basis for processing should be legitimate interests. You should do a legitimate interest analysis. You should stay away from consent. With respect to data transfers, international data transfers, also stay away from consent. That the best basis for lawful data transfers is that you're involved in a legal proceeding and you're trying to make a claim or defense in a case. Then data transfer is allowed. Why do I say stay away from consent? Because consent can be withdrawn at any time. And once you've relied on consent as a basis, the doctrine is pretty clear. You can't say, oh, we don't have consent, then we're going to rely on legitimate interests. Once you've gone down the consent road and it's withdrawn, you should stop processing. So a witness gives its consent, testimony doesn't go well, party says, we'd like to withdraw that witness statement. Regardless of what the arbitration rules say, arguably it's out because you no longer have consent to look at it.
Sure.
So consent is something that can really be toyed with. So, and that's something, at least based upon what I read from the excellent comments your firm provided on the roadmap, consent is sort of the cornerstone of Indian data protection law. So that's a place where you may have differences.
Sure.
And so first question, what is the basis for processing? We say legitimate interests, do a legitimate interest analysis if you want to be safe. Item number two, what is the reason for data transfer? There you can't rely on legitimate interest, you rely on processing of claims for purposes of bringing a legal claim of defense. So then, the one thing we like to talk a little bit about is why should you care, right? We say, you should look into these things early. You should think about doing a data protection protocol. And in the event, you should get everyone on the same page with respect to data protection compliance. And, why is that? Well, one thing is, you don't want to be fined, but I think the notion of fining is not what's driving this. Maybe at the party level, the parties might be really worried about fines and the institutions may be really worried about fines. I think arbitrators and lawyers particularly arbitrators, are less concerned about fines and more concerned about the fact that as arbitrators, we have an ethical duty to comply with the law. And if we're not complying with the law, we have a problem. So if we knowingly do not comply with the law as arbitrators, we put the award at risk, we put ourselves at risk for the next case. But more importantly, you're going to screw up your case because what happens is if you haven't thought about these things early, and counsel is sophisticated, and let's face it, in a lot of the cases where they can afford to pay our fees, counsel is sophisticated. At some point, they're going to realize that the data protection laws can be used as a weapon. And what do I mean by that? What I mean by that is, as an arbitrator, I say, you know what? Whatever your lawful basis is for processing, I don't care. That's up to the parties. So then I'm going to order some disclosure. And one party decides they don't really want that disclosure to be given. What happens? They orchestrate for that person to withdraw their consent to data processing. That means as a legal matter, I cannot order or they cannot comply with the disclosure order I've made. That's one way it can screw up the process. The other way is that somebody makes a data subject access request. So I'm an arbitrator, or I'm counsel, or I'm whatever. And one of the parties sees this case isn't really going well for them. So they say, we'd like the arbitrator to comply with this data subject access request, not counsel, the data subject. So somebody's mentioned in the evidence and they say, we want data subject access requests, we want to see every way you've indicated us in this entire file. And legally, I have to comply. So if you haven't thought about that beforehand and said, listen, whoever collected the data first is the one who needs to comply with these requests, then you have arbitrators, you have institutions, you have counsel, and you have the parties all obligated to comply with the data subject access request. So that's another way that this can be used to screw with the proceedings. So then the other thing that can happen, which we do see happening already, is I order disclosure, and that means the documents go to the United States. The European party says, oh, I have my data protection obligations. I can't send all these documents to the United States. How could you even, that's in direct defiance of data protection law in Europe. But if you've thought about that before, then you put in place a regime that says, okay, you guys, you're covered by the GDPR. Tell us how you'd like us to incorporate that into our disclosure requests. And that moment early in the proceedings, everybody's on the same page. But by the time you get to the nasty part of it, everybody wants to be nice to me. They've just met me. I'm going to decide $1 billion claim again, one way or the other. So they don't want to be jerks. But later, when they see things are not going their way, everything comes out. So you have to manage the process as a, arbitrator to avoid those risks. But for the most part, arbitrators are totally uninterested. So if I say, listen, guys, this is a European party, US party, Chinese party, whatever, we should think about having some guidelines in place before these issues come up. Oh, Paisley, you and your roadmap, we're not worried. And then later on, these issues do come up, and we haven't put in place a level playing field that will allow us to address them.
Sure.
So that's kind of how I see things. And that's why I think this is important, not only from a lawful compliance basis, but from a practical basis. And that's why I think it's important whether or not the Indian law, I hope for your sake, the Indian law is clear that arbitration is not covered, because that means, at least for domestic disputes, you have no issue. It means for arbitrations with countries where there is no real data protection law or it's not really enforced, you don't have an issue. But when you're arbitrating against European parties, Brazilian parties, parties that have serious data protection laws that they have to comply with, there I think it doesn't matter what your Indian Act says, really.
Sure. Got it. So I think this is obviously very, very critical. We wanted to discuss a couple of more topics as well in terms of the adequacy tests under GDPR and the enforcement regime. But I guess we are coming very close to the end of the session, and we might do one more round of this discussion sometime later. But there are a couple of questions on the from the participants. If you just touch upon one or two of them, and one is from Yashvi and another from Chetan. I think one talks about the virtual arbitration brings about one more uh, piece of stakeholder, which is the web platforms and other service providers which were not very active in arbitration, and they would have a lot of access to the information regarding the arbitration proceedings. Do they fall under the same regime, and they are just one additional service providers? That's how we look at it. And I think the second question, you dealt with it elaborately in your earlier answer, which is, while in India there may not be a violation, but you still end up violating a foreign law, and how to deal with it. So if you want to touch upon either of this briefly before we close the session at in 2 minutes.
So I will say 4 things. Number one, virtual hearings add a layer of data protection compliance requirements that everybody is ignoring. Every like this is a transfer of personal data amongst everybody who's on this WebEx. The same is true in a hearing. And so that means I, as arbitrator, I'm responsible for ensuring there's adequate cybersecurity. I'm responsible for ensuring that the data transfer allowed to occur. Everybody is, but certainly as arbitrator, I am if I'm governed by a modern data protection law. Everybody's ignoring that. It's true that the provider is too, but the provider is likely to be a data processor. So what it is required to do is to provide adequate security and to ensure the transfers are lawful, but they're not doing that either. So everybody thinks they're going to get a buy, which they're going to get a free hall pass, which they are for now, but going forward they will not. So people need to think about these issues. The second thing I would say with respect to compliance with foreign laws, I mean, I think if you're an Indian party happily going along in India and you have no connection to the European Union, the chances of them coming after you are very small. But they will come after me because of what you've done in an arbitration, because I'm subject to the GDPR and you're not. And that's another reason why arbitrators would be smart to think about two things. One, ensuring that all their co-arbs and everybody else signs the data protection protocol, which makes them personally responsible. And secondly, standard contractual clauses. Because standard contractual clauses means my Indian colleague agrees to the jurisdiction of a European DPO if they violate the rules. And that means that they won't come after me as the arbitrator, they'll come after you. And that's what I want. And that's the other benefit of standard contractual clauses that nobody's thinking about. So my advice to everybody is, in an arbitration, get everybody to enter into standard contractual clauses. That's really important for a variety of reasons, if they will. And if you appoint an arbitrator who's based outside the European Union and you're GDPR compliant, you have to be, then you should, and they won't sign standard contractual clauses, I think about another arbitrator. And that's all I've got time for. Those are my two pieces of concrete advice.
That's very, very helpful.
And read our roadmap. We spent so much
Yes.
time. Read our roadmap. You guys did a great job. If you have any comments, our comment period is closed, but from you guys, we'll take them. So
Sure.
thank you very much for having me. It was a pleasure.
Yeah, thanks a lot. And we are just about close to the time. And if there are any final comments from Payel or Aaron, otherwise we will close this webinar and I hand it over to Khaled to make the final announcements. Payel, Aaron, anything from you as closing remarks?
I think I'm just delighted that we could have Kathleen today with us, because I think more along with the participants, it has also broadened our knowledge base, because as in India, since we don't deal so much with data protection laws, specifically in the context of dispute resolution, I think a good subject for us to know more, considering we are focusing more on international arbitration, where we are going to deal with multiple parties and different jurisdictions. And it's been completely I would say more than useful. I would say it's knowledgeable session for all of us who are party today to the panel. Thank you so much, Kathleen, for joining us today.
Thanks for having me.
Thanks, Kathleen. I was just flipping through my notes and I had written down one point which I forgot to touch upon. I won't touch upon it now, but it was on data localization. And I know that wasn't a very big point for you because the GDPR doesn't have data localization per se. But the Indian government of late has been moving towards localization trends in terms of having data stored only in the country and not being allowed to leave the country. So on various fronts, on the e-commerce front, on the payments front, in different sectors and industries. So I think this is an additional consideration to keep in mind as well.
Sure.
The data is not allowed to be transferred in the first place. So
no, it's
Sure.
very important. And that's why when people complain about the GDPR, I say, think about that, because the other option is what Russia does, what China does, what you're saying you might start doing, which is data doesn't go. And then what
Yeah.
do we do in arbitration? So that's a good
That's
point.
true. Yeah, thank you. Thanks, Aaron, and thank you everyone again, including the participants, to come for this webinar, which is a little niche topic, but important for the dispute resolution practitioners. So Thank you, and over to you, Khaled, to close the session.